So, over the last few lessons, what we have been doing is talking about the concept of misrepresentation. We noted in the previous lessons that in order for there to be a successful claim of actionable misrepresentation, what is required is for there to be a statement or a statement of fact, and for that statement to have been false or at least misrepresented, or at least misleading, shall we say, and for there to have been the inducement by the other parties into the contract on the basis of that kind of statement. Now, in terms of contractual inducement, it requires that at least it makes a material contribution to the decision of whether or not that individual should enter into the contract. It doesn't necessarily mean that the individual in question only entered into the contract because of the misrepresentation. It just has to make a material implication into that. This lesson is going to talk about fraudulent misrepresentation. And fraudulent misrepresentation is the next major type of misrepresentation. There are two major other types of misrepresentation that we're going to look at. The first of them being in this lesson being fraudulent, the second in the next lesson being negligent. So, let's just do a basic overview of some basic concepts. And we're going to begin firstly with the idea of innocent misrepresentation. As the name suggests, innocent misrepresentation will take place where all of the elements of misrepresentation are satisfied, but it is done with a reasonable belief in the truth of the statement. So, if an individual makes a statement of material fact, and that statement of material fact is false or misrepresented, and as a result of that, that induces a contract to take place, but it is reasonably believed on the part of the person who made the statement that in fact they believed that it was true, that it was at least true that the statement that they made, then this is considered to be something known as innocent misrepresentation, i.e. all of the elements of actionable misrepresentation are there, but it was done with a reasonable belief in truth. Now, generally, the remedy in a case for innocent misrepresentation is either recession or damages. Rescission, shall I say, or damages. So it basically levies lighter remedies than the idea of it being potentially void or voidable as a contract. Just an innocent mistake, fundamentally. On the other hand, however, we have the idea of fraudulent misrepresentation. And we can look at fraudulent misrepresentation by reference to one of the most important cases in this area. The case that we're going to be referring to is the case of Derry and Peake from 1889. Notice, by the way, that a lot of the cases in contract law are very, very old. A lot of the basic principles of contract law are settled law and have been settled law for many, many years. Just bear that in mind. So the case of Derry and Peake was a case where it did not show that the claimant had a good claim for actionable misrepresentation. At the time, this was referred to as the tort of deceit. But it did outline the process that is required in order to show a situation of fraudulent misrepresentation. So this is an interesting case where we have a potential claim that doesn't actually materialize, but the courts do make an effort to discuss the process by which a fraudulent misrepresentation can, in fact, take place. The company in question had issued a prospectus which stated that its tramways were able to use steam power. This was not true, since this was something which would require support from the Board of Trade. The claimant in this case would see this prospectus and then, as a result of seeing this prospectus, make a decision on the purchase of those shares on the basis of this prospectus, even though within this we have the fact that it was not true, since it would require support from the Board of Trade. It was held that the defendant in the issuance of the prospectus did not rise to the level of an actionable misrepresentation, because essentially the claimant actually believed the statements in the prospectus was true. And so the courts will then go about the process of outlining instead the process of showing an idea of fraudulent misrepresentation. How is fraudulent actionable misrepresentation shown, or just easy to understand fraudulent misrepresentation shown? Well, the false representation must be made knowingly. It must be made without belief in its truth of the statement, or with an amount of recklessness pertaining to the truth of the claim. So you make a false representation, but you do so with the belief that you know it is true. Okay, no, it is false, should I say? Without belief, it's true in relation to the statement, or alternatively, with a certain amount of recklessness pertaining to the truth of the claim. So you might not know definitively and categorically if the claim happens to be false, but you are so reckless in your lack of understanding as to the epistemic truth of the claim that it can still amount to a fraudulent misrepresentation. According to Lord Herschel, we get this passage, and they say, quote, "Fraud is proved when it is shown that a false representation has been made, 1, knowingly, or 2, without belief in its truth, or 3, recklessly, carelessly, whether it be true or false." So, Lord Herschel makes something of a hair-splitting delineation between a false representation being made knowingly or without belief in its truth. So essentially what these two things represent are essentially the same thing. If you say, "I know this is false," versus "I do not believe that it is true," there is a slight difference, as you can probably understand, but they both derive basically at the same conclusion. But then the third point is that you can do so recklessly, carelessly, as to whether or not it is true or false. And this is how we prove fraud can be shown in a case of fraudulent misrepresentation.